So the Supreme Court in a 6-3 decision overturned a California law that requires your name and address be turned over if you donate to a pro-2A group. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to overturn these 2A violations, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors of the channel, and that is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look at USCCA, and I'll put a link to them down in the details section. So like I said in the intro, the Supreme Court recently came out with a 6-3 decision that overturned a California law that required that information be released to them on donors who donate more than $5,000 to any pro-2A organizations or any charitable organization in the state of California. The case we're going to be talking about in this video is Americans for Prosperity Foundation v. Bonta. It was originally Becerra, but of course that changed. And this case involves First Amendment rights issues and also implicates Second Amendment rights issues. This case involves whether or not the state of California may demand that charities and nonprofit organizations that solicit funds in California must also hand over an unredacted form to the state of California that contains the names and addresses of all donors who give $5,000 or more to that organization in a single year. So for a lot of you in the state of California who donate to pro-2A organizations or just constitutional organizations, your ears probably just perked up because essentially the state of California is demanding that those organizations that you give your money to must then turn over your personal information to the state. And actually there's been some issues in relation to that as well, and some potential retaliation issues that popped up and were actually addressed in this case as well. Now, the state of California put this invasive law into place to allegedly seek information to aid in the investigations on charitable misconduct. So that is the rationale the state of California put behind having to have this law in place, because they said that there is charitable misconduct going on. And so we need information on donors that donate $5,000 or more. And we need all their information so that we can make sure that there is no charitable misconduct going on with these organizations. Now, Americans for Prosperity Foundation is a grassroots nonprofit which opposed handing over the unredacted forms to the state of California and therefore instituted this lawsuit we're talking about against the state of California. Now, this case made it to the Ninth Circuit, and ultimately the Ninth Circuit held that the California requirement did not infringe on otherwise anonymous donors' rights to associate freely under the First Amendment. Ultimately, the Ninth Circuit made its determination despite evidence that California had accidentally and allegedly accidentally made hundreds of donations public, and that Americans for Prosperity Foundation donors actually had in the past been subject to harassment and other retaliation for their affiliation with that organization. Now, this American Prosperity case was actually supported by other pro-2A organizations like FBC, who filed an amicus brief in support of plaintiffs in this case who were taking this up to the Supreme Court. And ultimately this did make it up to the Supreme Court, and we recently got a decision from the Supreme Court on this issue. And ultimately this came down to a 6-3 opinion written by the Chief Justice Roberts. And ultimately the court held that the California law compelling disclosures of donor names and addresses was not narrowly tailored to meet the state's interest in investigating charitable misconduct. So that was the whole basis, like we said, that the state of California had for why they needed this law, was to investigate charitable donations and charitable misconduct that could be taking place. And the Supreme Court said that interest and this whole law was not narrowly tailored to meet that state interest. Now, I just wanted to read you some of the language from Justice Roberts in his opinion. His opinion was not followed in full by all the judges, but one of the issues was the level of scrutiny that should be applied. He wanted to apply this thing called exacting scrutiny, which is not actually the highest form of scrutiny, which is strict scrutiny. It's kind of this weird in between. So they wanted to apply exacting scrutiny, and actually he was followed in that part of the opinion by Kavanaugh as well as Amy Coney Barrett. In this part of the opinion on the whole scrutiny issue, Justice Roberts wrote that courts should use exacting scrutiny, which looks for a substantial relation between the disclosure requirement and the sufficiently important government interest. But he also continued that although exacting scrutiny does not require a disclosure requirement to be the least restrictive way for a state to achieve its goals, it does require the disclosure rules be narrowly tailored. Ultimately, Roberts, in his opinion, found that this broad requirement of disclosure of donor information would actually chill donors wanting to actually give their information to these organizations like pro-2A organizations, because effectively the state of California would get that information, maybe release it, those individuals could be retaliated against, or the state of California would use that information themselves to retaliate against these individuals. Now, this decision pretty much went along party lines, with Justice Roberts writing the majority opinion, and then you had Kavanaugh, Amy Coney Barrett, Gorsuch, Alito, and Thomas all writing again that this California law was indeed unconstitutional, violated First Amendment rights and your freedom to associate in the state of California, and pretty much that this law just is way overbroad. It is not narrowly tailored at all and just infringes on core rights. Now, this is something that is good because it overturns a First Amendment violation in the state of California, but also maybe signals with some of these decisions we're now getting from the Supreme Court on some religious issues, and then also in this First Amendment context, that maybe when they took up this case Corlett, which they are going to be hearing soon, the New York State Rifle and Pistol Association v. Corlett case, which deals with New York's carry permit scheme. They are going to be hearing that case at some point, and of course, when we get that information, I will update you guys, but this is maybe a good sign that finally the Supreme Court is actually going to rule in favor of constitutional rights and overturn a lot of these state laws that are just overstepping and violating our constitutional rights here in this First Amendment context, and in some of these other contexts that we've had recently, some religious contexts, and then maybe in the New York State Rifle and Pistol Association v. Corlett case, they will finally address how the state of New York in that case has overstepped two-way rights. So I just want to get this information to you guys because not a lot of people are talking about this case, and I think this is a big First Amendment win, but it is also good for 2A rights as well, because a lot of us do donate to pro-2A organizations, and we do not want that information getting out, for example, to the state of California for them to use against us, or to the public at large, who we just don't want them to know how much money we're donating, who we're donating to. We don't want our name and addresses out there so people could retaliate against us. But this is a good step forward, and at least the Supreme Court is ruling in favor of constitutional rights. So if you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, subscribe. All those things help to fuel the algorithm, helps to signal to YouTube that you guys see value in these types of videos that I put out. It helps to push it to more individuals out there on YouTube who want to hear this type of 2A news, who want to hear about their constitutional rights, who want to help fight for their constitutional rights. So if you guys would please just leave a comment, even if you don't want to leave a comment, just drop a comment that says, hey, I'm just commenting to fuel the algorithm. I really appreciate that, and that really does help the videos. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.